Hello, welcome everyone, and thank you for joining us for today's presentation. My name is Tricia Riley, and I am the chair of the Labor and Employment Group here at Merthyr Kalina. I'm going to take a moment to go over a couple of points. All callers are in listen-only mode. If you have questions during the presentation, you can write them in the questions box of your webinar toolbar, and we will answer them at the end of the presentation. This webinar is being recorded. All of today's participants will receive an email following today's presentation with the PowerPoint slides, a link to the webinar, and an attendance certificate. So let's begin. So this is an era of social change in which we have had a lot of cultural upheaval. It's been a very active and important movement and movements that have yielded real impact in the workplace. So the hashtag #MeToo movement started about a year and a half ago in October of 2017. The New Yorker broke the Harvey Weinstein story, in which he had been accused and then later convicted of various assaults, harassment, and intimidation of women in order for them to get parts in his movies. That had a domino effect, particularly in the media industry, in which men who had been abusing their power were called out on it and, in fact, were terminated. And this was especially true in television, in the movie industry. We saw actors, we saw leaders of industry, and it then had an impact on workplace in general. And what it did is the movement itself brought new awareness to workplace harassment issues. So how has this social change impacted workplace culture? Before I get to the slides, I want to mention here, as we all know, that pending before the Connecticut legislature is a bill, a Senate bill, which is now being debated by the House, which will change the sexual harassment prevention training that is going to be required in Connecticut. And it has various other components with regard to sexual harassment and discrimination. The bill is still under discussion, but I think that there probably very much is, it's very likely that there's going to be a new sexual harassment bill in Connecticut, so we'll keep our eye on that. So what we've seen is that the social change has impacted workplace culture because state legislatures, and even in some cases, for example, New York City, city laws are changing such that the workplace is required to take these issues very seriously. So what are the best practices for your workplace in order to ensure that the laws on sexual harassment are being followed? The first that we've seen and that studies have shown is that the company must embrace the change at the highest level. In other words, the C-suite executives must embrace the culture of change and the culture of no harassment. And the reason for this is if you don't have leadership at the top committed to diversity and anti-harassment, you are not going to be able to have an effective workforce and an effective implementation of these policies. And in fact, we recommend that the executive level managers, even up to the president and CEO, undergo training because they will set the tone for the leadership. So one question that we come up against a lot is, have interpersonal boundaries changed as a result of the hashtag #MeToo movement and other movements, and has our training changed around interpersonal boundaries? And I would say that what has changed is the awareness. So what's really important and what we train is that people who are managers and supervisors need to be very, very aware of what they say, what they do, including interpersonal boundaries. And I had a bet with somebody last night that I couldn't get through this presentation without naming a certain political person who's been in the news recently for quote-unquote interpersonal boundary issues. So I haven't named the name, but the point of it is that somebody might think, you know, a hug, a supportive hug is appropriate as a way of showing support to somebody. But the problem is in the workplace, and what we train for is a supportive hug from a manager to a subordinate might not be the same thing as a supportive hug between friends. And so if you are a manager, what we train is you have to be super rigid in your personal boundaries. It's not to say that you can't notice things. That's part of your job too, is that you are supposed to notice the morale in the workplace. You are supposed to notice how people are interacting with one another. But you have to be very conscious of your own interpersonal boundaries and language. So I really like to put this in historical perspective. I think it's so interesting because I've been doing sexual harassment prevention training throughout my career. And in some ways, anti-harassment law is new, and in some ways, it's been around for a very long time and has become reinvigorated with the hashtag #MeToo movement. So I have these pictures up here for a reason. So the first one on the far left is somebody, let's just assume she's in the 1950s. This is the Mad Men era for those of you who watch that show. And the bottom line on that photo, the reason I chose it, is that women had no protection in the workplace in the 50s, none whatsoever. So in other words, harassment was rampant. Assault could occur. If it were an actual physical assault, maybe you could go to the police, or a sexual assault, but you would not be treated well. It would be deemed to be your fault. What were you wearing? How were you acting? So for people who were working, women who were working in the 40s and the 50s, the workplace was difficult, could be a very difficult place to work. Now, the slide in the middle, the Rosie the Riveter, is really interesting because that's a 1940s slide. In the 1940s, as we all know, during World War II, women had to take over the jobs in factories primarily that men used to have because the men were all at war. And so during that era, women actually had a lot of empowerment. It was women in the factories. So then what happened is when the men came back, women lost their jobs. Literally, women could get fired, did get fired. And the reason is that there were no protections for women in the workplace in the 1940s. The men came back, so you had to leave that job and give it to a man. Now fast forward to the current era, where those of us who are working mothers, working people, working women, we feel like we're juggling a million things at once. And the good news for this is that we do actually have more protections in the workplace. We do have ways to protect ourselves, and the law is much more supportive of women working in the workplace, and particularly with regard to harassment. Now, I want to make a statement here that, of course, the anti-harassment laws apply not just to women, they apply to men. So if it's a male supervisor harassing, if it's a female supervisor harassing a male subordinate, the anti-harassment laws will apply. So when I do my harassment training, I sometimes default to saying, the male supervisor and the female subordinate, because that still, in this day and age, tends to be the paradigm. However, it can easily be flipped, and it has been flipped, and both kinds of harassment are illegal. Same-sex harassment in the workplace is illegal, and we have extended our training to say harassment on the basis of any protected category is illegal in the workplace. So while we come at this from the perspective of working women in the workplace and protections for women in the workplace, we have to realize that throughout these eras, it has been expanded, and we'll talk a little more about that. So, I mentioned in those earlier slides showed in the 1940s, no protection for women in the workplace, 1950s, no protection for women in the workplace. So when did we finally get some minimal rights? 1964, Title VII of the Civil Rights Act, which made discrimination on the basis of race, sex, color, national origin, and religion illegal. This was primarily a statute that was put into effect to stop race discrimination, or at least to address it in the 1960s and the 1950s. As we know, again, that was an era of social change, significant social change. In fact, the sex prong of the 1964 Act was added on at the last minute as a compromise. It almost didn't get in there, but it did, and that's important. So starting in 1964, at least the law was starting to develop that discrimination against women was illegal. Now, in 1979, so it wasn't until 15 years later, a professor, Catherine MacKinnon, wrote a book called Sexual Harassment of the Working Woman, in which she made the argument that sexual harassment is a form of sex discrimination. So what we found before she developed this theory is that the courts were saying, well, 1964 Civil Rights Act says women have to be treated the same as men, but it doesn't really address harassment about women having to put up with actual, intimidation and touching and language. So Catherine MacKinnon developed this book. It's still, in this day and age, a really fascinating book to read. You can get it. And that theory ultimately helped convince the Supreme Court that sexual harassment against working women was illegal under Title VII. So, however, because law changes really slowly at the court level, this did not get to the Supreme Court until 1986, this issue of sexual harassment being illegal. And so Catherine MacKinnon's book is published in 1979, but it's not till 7 years later that the Supreme Court has a case in which there is sexual harassment. It was called Meritor Savings Bank versus Vincent. This was the case that established that sexual harassment is illegal. When I think about this, 1986 was not very long ago. So when you think about it in that way, it's kind of astounding that protection for women, sexual harassment prevention, is a fairly new development in the law. And what happened in this case is a teller was very badly harassed by her supervisor, basically told over about a 6 or 7 year period of time, if you don't engage in this affair with me, this sexual conduct with me, you will be fired. And she needed the job. And so under duress, she went along with everything that he required to keep her job. She was finally fired, and she sued, and she won, ultimately at the United States Supreme Court, and established this law. So then the cases start to follow Meritor Savings Bank and say, okay, harassment in the workplace is illegal. And the kind of harassment that was addressed in the early days of these cases was really, really bad behavior in the workplace, really horrible conduct that women were being subjected to. In 1992, Connecticut, which is a very progressive state for employees, required sexual harassment training. I believe it was the first state in the country to require that. And so we've been doing this training for over 25 years. It's quite interesting to think about that. And so I've been doing this training myself for over 25 years. And honestly, before the hashtag #MeToo movement and before all the allegations of Weinstein and other very powerful people came out, I thought people were behaving themselves in the workplace. As a practitioner, I thought the sexual harassment prevention training had helped. I thought managers understood that they could have very serious repercussions, including individual liability for engaging in this kind of conduct. And I really thought quid pro quo harassment, which is sleep with me or else you'll be fired, or vice versa. If you don't sleep with me, you won't get a job, that kind of thing, an actual requirement of sexual activity for a workplace benefit. I really thought that had almost been eliminated. I was wrong. The hashtag #MeToo movement showed that this is still pervasive in certain kinds of workplaces, where, particularly where there's somebody who's so powerful and has gotten away with this for years. But now what happened is this is changing, and it will continue to change because the laws are finally starting to catch up with what is going on in the workplace. Okay, so 2017 is the hashtag #MeToo movement, and we all start to realize this has not been eliminated in the workplace. Women are still being subjected to egregious conduct. Okay. So this is an interesting slide because it is the Equal Employment Opportunity Commission, as we know, is the federal administrative agency to which employees can bring claims of discrimination and harassment. In Connecticut, we have the Commission on Human Rights and Opportunities, and the EEOC defers to the Commission on Human Rights and Opportunities. So an employee brings a claim at the CHRO here. It can be dual filed with the EEOC. The CHRO investigates it, and an employee can then be considered to have filed under both the EEOC, through the EEOC and through the CHRO, and can bring both state and federal claims after that. So in 2017, the EEOC conducted a very long research project. It had actually conducted it starting the year earlier, completed it in 2017. What it found was that charges filed with the EEOC by employees working for private employers or state or legal government, so it's both public and private employers. In 2007, 33% of the cases filed alleged harassment on the basis of race, 28% harassment on the basis of sex, 20% disability, 12% national origin, 5% religion. So as I said earlier, these harassment can be based on any protected category, and these were the statistics showing the highest areas in which harassment claims were based. Now, I want you to look at that 28% for harassment. That seemed very low to me. And I anticipated that because this study had been finished in 17, it hadn't, the awareness that was brought to light as a result of the Me Too movement hadn't yet translated into more claims being filed. And in fact, that's what happened. So when we fast forward, we'll get to the slide in 2018, but when we get there, we'll see that, in fact, claims did go up in 2018. So this was another very important and interesting finding in that report. These are the employee responses to harassment. The most common response from victims of sex-based harassment is not to report. So not to report to HR, not to tell anybody in their company. And rather, the first is to avoid the harasser, avoidance. That's not always going to work because if it's a true harasser, they are not going to give up. Second is deny or downplay the gravity of the situation. Laugh it off, just, oh, it's nothing. Attempt to ignore, forget, or endure the behavior. The least common response is to take formal action, to report it internally or file a lawsuit. This is not good for companies because companies should want their employees to report these things internally so that the company has an opportunity to investigate and take appropriate action. So what does that mean from an HR perspective? It means open door policy. It means distribution of the anti-harassment policy. It means making a complaint procedure that's easy to follow and easy to implement. And of course, it means immediate investigation and taking these things seriously. And I always say when I do my sexual harassment prevention training, we talk about addressing interpersonal workplace conflict at the lowest possible level. So HR should walk around and see how everybody's doing. Not all interpersonal workplace conflict rises to the level of harassment, but a lot of interpersonal workplace conflict that is ignored or downplayed can then become harassment because it's not dealt with in the first instance. So here's the 2018 data that I was referencing. So the EEOC received 7,609 sexual harassment complaints in 2018, which was a 13.6% increase over 2017. Still not probably quite as big an increase as I would have thought, but it did increase, and that's what we would have expected. Now, the amount of settlement, the amount of money that went to settlement in 2018, $56.6 million. That's a big number. It doesn't say how many companies that involved, but it's big business in terms of it has a major impact on the company's bottom line. And the EEOC did credit the significant impact of the hashtag #MeToo movement in the number of sexual harassment and retaliation charges filed with the agency. Again, it's awareness and support. So the first thing is awareness that people feel, they know this is illegal. And then I think there's been a trend of feeling it's because it's not just me. It's not me. Other people have experienced this in the workplace. I feel more supported. I can make a complaint. And frankly, in terms of that support role, in our anti-harassment training, we talk about coworker and bystander assistance to help people who feel that they're being harassed in the workplace. Coworkers can help and support their colleagues. So what we're trying to strive for is a healthy workplace. We want to strive for the highest level of professionalism. We want to be very mindful and aware and cognizant of how we come across as a supervisor or manager to our subordinates. Are we following appropriate interpersonal boundaries? Are we being too close in space? Are we using the right language that we should be using? Are we keeping our tempers under control? And are we eliminating inappropriate comments or behavior? So I always talk about the manager setting the tone, right? So we talked about the C-suite executives, the highest levels, setting the tone. Then the next level manager setting the tone. All of this should create a tone in the workplace, a morale in the workplace where people are doing their work, they're acting professionally, and that is what is to be expected of everybody in the company. It really helps when the company knows its goals, knows its mission statement, and works creates the healthy workplace around those values. So we've put together a slide of a few points for the best practices for a healthy workplace culture. And so, as we talked about, I think the best way to do it is for everybody to discuss and to know what the mission of the company or the organization is. Oftentimes, you'll put the mission statement in your handbook. I know we have a lot of organizations here on the line that are either nonprofit, healthcare, some education, whose missions are very important and very humane. And so we want the workplace to reflect the mission of the organization and our interaction with each other to reflect the mission of the organization. We want an open door policy for HR so that people can report what's going on, or if you have a call-in anonymous system, which a lot of people find helpful as an adjunct to an HR open door policy, to make it easier on the employee to be able to make a complaint so that it can be addressed, will help to ensure that their concerns are being addressed. As I said earlier, for managers in HR to address interpersonal conflict before it escalates, de-escalate conflict. Of course, if the conflict itself is harassment and it's already gotten that far, we have to do the investigation, we have to address it, we have to stop it. But sometimes if you're just talking about interpersonal conflict, it might be a little, just a quick meeting between two people to try to iron out whatever it is that seems to be the problem. Again, maintain, distribute the anti-harassment policy, provide training, make sure everyone, including the managers particularly, know the reporting procedures and what their obligations are. And by the way, in this regard, I always say there is no such thing as a formal complaint. Okay? If someone makes a complaint, they don't have to put it in writing. They don't have to make a quote-unquote formal complaint. A complaint is a complaint. So if a subordinate goes to her manager and says, my coworker keeps calling me really horrible names, he's making strange faces at me, and he keeps asking me out, and I'm feeling extremely threatened and intimidated, the manager does not say to that person, go file a formal complaint with HR. That is the complaint. So the manager may say, thank you for letting me know this. I will let HR know. Please feel free to go to HR yourself, but this will be addressed. Also, we all know the problem with an employee coming to a manager or to HR and saying, I have something I have to tell you, but you have to promise to keep it confidential. No one can promise to keep anything. No one in a position of a management position in an organization can promise to keep anything confidential, except on a needs-to-know basis for an investigation if necessary. So you have to say, well, if this is a workplace issue or involves somebody, obviously you need, please tell me. I can help you. I'll try to help you. I just can't promise confidentiality before I know what you're going to tell me. Then, as I said, bystander assistance and training is another area that organizations are using to try to decrease and de-escalate harassment. So bullying versus harassment, is there a difference? What's interesting about this is there's so much overlap. It's kind of, in some ways, a little bit silly to try to parse out the differences, but I will say this, under the law, currently in the United States, no state has an anti-bullying law per se. There have been proposals. It has been proposed in Connecticut. That's why I have the middle bullet that says, is bullying legal in Connecticut? Maybe, only because we don't have an anti-bullying statute, nor does any other state. So where does that leave us? That leaves us with a situation in which arguably a manager who's loud and mean and yelling all the time, but not using sexually explicit terms, not targeting a certain group, he's just the equal opportunity bully, might not be able to be sued for that. That is not the way we manage our workplace. That's the way I defend a case, if it ever gets there. That's not how we manage the workplace. We manage the workplace to say the best practice is to counteract bullying and harassment. And frankly, if you get a bullying complaint, I would definitely advise investigating it pretty much the same as you would a harassment complaint, because sometimes they are the same thing. There's bullying involved, and the person's only bullying a certain group, and that could just be harassment. So, as I was saying earlier, because I'm aware of the organizations on the phone, I know that some of you have some corporations will have corporate values that are very important, but some of the organizations on our phone may have values that are very humane, very client-oriented, patient-oriented, people with special needs-oriented, education-oriented. Almost every organization listening in on the phone today has a corporate value or an organizational value of respect. Some have caring, compassion, cooperation, support, diversity. All of these are values, corporate values. And again, look at your mission statement. You probably have something that articulates your corporate value. Maybe it's efficiency and, being ahead of the curve and having innovation. All of these things, these company values drive the corporation forward. And everybody should be on board with this. None of the corporate or organizational values are going to involve harassment or anything that's going to undermine moving the organization forward and supporting the mission of the organization. So diversity, studies have shown that, in fact, a diverse team helps with innovation, helps with creative ideas, helps with thinking outside of the box, because people come to the problem with different perspectives. So rather than isolate somebody because of their differences, it's a much better practice in the workforce to be inclusive, obviously, and there's a big movement toward inclusivity. Again, I think of it just as if we're all working and we're working toward the same goal, we don't have to focus on our differences. We're focusing on the job. But studies have shown that a more diverse workforce is likely to create a more innovative culture. So what should your company do to protect its differences? Establish rules and policies to ensure that all employees are treated fairly and equally. Again, the same policies that apply to anti-harassment are going to apply to anti-discrimination. Strive to teach employees to respect differences. Encourage employees to confide in supervisors or management when rules or policies are breached. And establish procedures to report if there is unfair or unequal treatment. Establish a complaint procedure to report harassing or discriminatory treatment. Again, I think all of these issues are on a continuum, and they're usually dealt with by HR, and if it involves the need for an investigation, that HR is usually, in my experience, the organizational part of the corporation or the organization that will undertake the investigation. This is just a reminder that under Connecticut state law, we have a much broader group of protected categories, and they include already sexual orientation or gender identity or expression. And some of you who might be following the cases as they're wending their way up to the Supreme Court, the issue of sexual orientation under Title VII may very well make its way to the Supreme Court, because right now there is a split in the district court level as to whether sexual orientation is covered under Title VII. It's not explicitly covered. So to me, this is almost hearkening back to the 1986 Vinson case, in which the Supreme Court found that although sexual harassment, the words themselves were not in the Title VII statute, sexual harassment was a subset of sexual discrimination. I suspect it's going to be very interesting to watch this, although it's going to change depending on who's on the Supreme Court, but the argument would be, even though sexual orientation isn't explicitly named in Title VII, it is a subset of sexual discrimination. In Connecticut, we don't have to get into the legal theory behind this. It's already illegal in Connecticut to discriminate against somebody on the basis of sexual orientation. And again, this includes harassment. Illegal to harass anybody on the basis of any of these protected categories in Connecticut. So as I mentioned earlier when we saw the slide from the EEOC and the amount of money and settlements that have been paid out, committing sexual harassment in the workplace is costly. So there's a business case for a harassment-free workplace. The direct cost, the largest jury award still in 2012, to our knowledge, this has not yet been exceeded. That's not to say there haven't been some settlements that we've heard about that have been really high, although many of those were confidential, and that may not happen going forward because of changes in law. But the largest jury verdict was $168 million. A lot of money. Obviously, there's huge damage to the reputation of the organization, inability to attract and retain talent, and you have to make a cultural change. We all may recall that a few years ago, Uber was criticized for its hostile work environment. It subsequently hired someone to address that, to embrace diversity. Although Uber's having some other issues with regard to wages, it had to really look at its culture, and it was trying to make a change in terms of the damage to reputation because of alleged hostile work environment. And that's a big problem. Other indirect costs are decreased productivity, increased turnover, negative psychological well-being. Organizations that have high harassment or hostile work environments have decreased productivity. So this is where we circle back to the healthy workplace. If we are proactive in making our workplace healthy, productive, and if there is a very well articulated and understood mechanism for making complaints and having them addressed, then we can make the workplace more productive, which is all anybody really wants. Okay? As we probably all know, retaliation is also illegal. So if someone files a complaint, if someone makes a complaint of harassment internally in the workplace, and then they have an adverse employment action shortly thereafter, they are going to have on its face a retaliation claim. Now, what we know is that what sometimes happens is somebody might be having poor performance, they might be on a performance improvement plan, and after all of that performance, all the performance issues have already been established, they then make a complaint. When that happens, the record shows that the performance issues predated the complaint, and the retaliation claim will usually not succeed. In terms of associational discrimination, this can run a couple of ways. There have been cases where, for example, a spouse in the workplace feels that he was retaliated against by having an adverse employment action occur to him if his wife made a complaint of harassment. Another way this works is if I participate in an investigation on behalf of somebody else, and then I'm faced with an adverse employment action, I might say, well, this was in retaliation for my participating in the investigation. So the point of the retaliation is to keep an eye on people who are being subjected to, even if it's appropriate, personnel evaluations that are bad or performance improvement plans. Look at the timing on that. It's not to say it should stop if somebody has made a complaint. It's to say if you're putting them on a PIP, 2 weeks after they made a complaint of harassment, you need to look at that and make sure that you have the documentation to show that it was in the works before they made the complaint, so that you can show that it wasn't in reaction or in retaliation to the complaint. So retaliation is an adverse employment action. It can be demoting, harassment, firing. It can be an employee may say a bad performance review or a series of bad performance reviews that then actually result in a demotion or some potential adverse action. The cases say that the adverse action has to be an actual firing or demotion, but my view is that in Connecticut at the CHRO, if you have, somebody could probably bring a claim that won't be dismissed right out of the box if they say, I made a complaint of harassment and then I got a series of bad performance reviews. The CHRO would probably look at that as retaliation. So as I was saying, the bystander coworker intervention is another more recent practice that I think has come out of the hashtag #MeToo movement. We didn't really talk a lot about bystander or coworker intervention before all of this came up in 2017. It was discussed in the context of colleges and universities with students helping each other out if they thought they were in trouble at a party, that kind of thing. If your friend is drunk, don't let her go upstairs, with a young man she doesn't know, for example. And if your friend is drunk and you want to try to calm him down, sit him down, try to help him out. This happened at the university level. That's where this whole idea first started, the bystander intervention. It's now been moving into the workplace as a way for coworkers to support one another during these situations. So, for example, we want to talk about de-escalation, but that doesn't necessarily mean that if you're in a group of coworkers and somebody's making a bad comment, you go in there and that you have to, stop it right then and there, because that might actually escalate and cause a fight. you might want to just say, hey, change this topic. You might want to move the person out if one person's being targeted, or maybe you do feel that it's the appropriate time to say, that's not very funny. Let's move on. So it does take a lot of judgment to determine how to de-escalate a group situation, but it's something that coworkers need to think about in terms of helping and supporting one another. Another approach is if a coworker wants to be supportive, go to the person later, ask if they want some help, say, I observed this situation. A coworker who observes a situation that they think is inappropriate, they don't need anybody's permission. They can go to HR themselves and say, I observed this, I overheard this is not okay, and then that needs to be dealt with by HR. So if an employee is offering support and he complains on behalf of others, he is protected or she is protected from retaliation. So a complaint on behalf of others is a protected activity. So again, as we move forward in the workplace, I see the focus shifting from reactive to proactive, shifting from punishment to prevention, shifting from punishment to promoting values of the organization, emphasizing civility, respect, getting the job done. And these values in the workplace apply to everyone, not just to protected classes. We're all here to do the job. Again, steps to consider: be proactive, don't wait for a complaint. And what do I mean by that? If you're HR, walk around. If you're a manager, observe how people are getting the job done. Observe your own behavior. Make sure that you're setting the example. You can check in if you're a manager or HR without being intrusive. Here at our firm, I like the way the HR person goes from office to office and sends an email around and says, I'll be in the New Haven office. I'll be working in XYZ office. Please stop by if you have anything you'd like to discuss with me face to face. That's a great best practice because, she shows up in the offices, she invites people to meet with her, and she will also check in with people. Make clear that employees can see you about anything. It doesn't have to be, complaint. So check in. And as I said previously, there is no such thing as a formal complaint. Okay, so now we're going to take questions, which you can email, right? And
I'm just going in here to the questions.
Okay.
Are members of U.S. Congress exempt from sexual harassment? Are members?
Well, I don't know. Does Title VII apply to Congress? I don't represent Congress, so I don't really know the answer to that question. There've been, I don't know. Okay. Good question, but the sexual harassment law it's state specific, so they wouldn't be subject to a District of Columbia law, and are members of Congress subject to Title VII. Probably somebody out there knows that. I kind of not sure they are, but okay, that's it. Okay, so thank you for listening, and we've come to the end of our program. We hope that you found the information helpful, and all of today's participants will be receiving an email with the PowerPoint slides, a link to the webinar, and an attendance certificate. So please keep an eye out for that. And if you have any other questions, please feel free to reach out to me by email. And if I can't answer them, I will find out the answer for you. All right. Thanks very much.